Imagine if the most popular rifle in America, the AR-15, and magazines were declared outside of the protections of the Second Amendment. Now, that's not just a hypothetical, that is currently in front of the Supreme Court for consideration. Now, the question before the court is very simple. Does the Second Amendment guarantee the right to possess AR-15s and magazines? So let's talk about some new news in these cases and what's potentially happening going forward. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. You can also click on the notification bell and turn on all notifications, because that helps to ensure that you actually get these videos when I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always expanding upon their memberships and their benefits to make sure you get the most out of your coverage. In fact, one of the new things that they added is they're guaranteeing 4 attorneys to your self-defense case. So if you want to check them out, use the links down below. And also, if you use my code ARMEDSCHOLAR, you can get $25 off of your sign-up plan. Now, as I mentioned in the intro, in this video, we're going to be discussing a critical rifle and magazine ban challenge that are currently going to the Supreme Court once again for conference, and once again are going to be considered by the Supreme Court. Now, the primary case that I want to talk about is Vermontes versus Cook County. And in that case, the petitioners are individual citizens along with organizations like Second Amendment Foundation. They are challenging Cook County's ordinance, which makes it a crime to sell, transfer, or even possess so-called assault weapons as defined by that ordinance. Now, that ordinance term and that definition essentially includes over 100 rifles by name, and then also it bans a bunch of rifles by characteristics with features like pistol grips, folding stocks, muzzle brakes, very similar to what a lot of other, counties or cities have done, and also states like California. And these cases try to leverage some of the recent statements made by some of the justices, like Justice Kavanaugh, after the Snope denial case, where there was a rifle ban out of Maryland. That Snope case went to the Supreme Court, it was denied, but Justice Kavanaugh said that they would need to address this type of rifle ban issue in a term or two. The plaintiffs now push this case and the Duncan case as a vehicle to fulfill those promises, and the Supreme Court has once again relisted a review of these cases, for another conference at the end of this week on January 16th. Now, this could mean a few things, and also gives us some insight potentially on what's going to happen going forward. Now, if you're not aware, this is kind of how this case got in front of the Supreme Court. Essentially, back in 2021, the rifle ban lawsuit was filed in a federal district court in Chicago. The petitioners challenged the county's ban under the Second Amendment, and essentially flash forward to 2024 while the case was pending. Illinois passed a statewide assault weapon ban, overlapping with some of the Cook County restrictions and ordinances. Now, around the same time, the Seventh Circuit decided a case called Beavis versus Naperville, upholding Illinois' law and claiming that AR-15s were too militaristic to be protected arms. They ruled that firearms that are useful in military service could be restricted by a state or a locality. The district court, bound by the Seventh Circuit's ruling in this case, decided to uphold Cook County's rifle ordinance and these restrictions on rifles. The district court issued a summary judgment in favor of Cook County, and then going into 2025, right after the Snope case was denied review, and you had that statement from Justice Kavanaugh, the Seventh Circuit then quickly affirmed what the lower court said in their ruling, upholding once again Cook County's ordinance. The Seventh Circuit leaned heavily on what happened in Beavis, treating AR-15s as essentially civilian versions of M16s and too militaristic and therefore outside of the Second Amendment's protections. And now the petitioners are asking for the United States Supreme Court to step in and resolve this conflict. They asked for the Supreme Court to declare once and for all whether Americans have the constitutional right to own AR-15s and similar semi-automatic rifles that states and localities are banning. The petition argues that circuit courts are split and deeply confused on how to apply Heller and Bruin when it comes to rifles and these types of restrictions. Some courts say that AR-15s are arms, but can still be restricted anyway. And then on the other side, you have some circuit courts and some courts that are essentially saying that rifles like these are not arms at all and therefore have no two-way protections. Cook County responded by arguing that the court here should once again just simply deny review of this rifle ban case and once again punt this issue. Cook County argues that this case doesn't warrant the court's attention for multiple reasons. First, they say that there is no circuit split on this issue of rifles being protected arms. Second, they claim that this case is a poor vehicle since they argue the plaintiffs failed to follow some basic court procedures, kind of skipped discovery in their eyes, offered no admissible evidence, and kind of rushed the process to get to the Supreme Court. Finally, Cook County contends that the lower courts were right on the merits of this issue, even if all that other stuff is overlooked. In summary, they say essentially this case is procedurally defective, legally settled, and not the right vehicle for the Supreme Court to revisit and rule on this whole assault weapon ban issue. So at its core, this case asks for the Supreme Court to finally do what we've been asking them to do for many years, which is take up a state or locality rifle ban, take up these rifle bans, and hopefully strike them down. This case went to conference recently, back last Friday, with another, two-way case, the California Duncan versus Bonta case. The Duncan versus Bonta case, which deals with California's magazine bans. These two cases have gone to multiple conferences now together. They've survived now multiple conferences. Even though some other two-way cases went to those same conferences, but then the following order list, denied those cases, but these two are still surviving and have been relisted once again for conference this Friday on January 16th. Now, you may wonder, why is the Supreme Court relisting these cases so many times, and why is this important potentially for the outcome of what could happen? Well, that is because all the Supreme Court analytics and tracking and data on prior cases show that a case has a higher odds of being granted review by the Supreme Court if it's relisted, but only one time. In fact, according to the data from the court's 2016 to 2020 terms, between 31% and 43% of petitions that were relisted at least once were eventually granted review. And between 66% and 75% of all cases that were granted review were relisted at least one time. So the fundamental truth is that a case relisted just once has a far better chance to be granted review by the Supreme Court. But the other side of that, and the data also shows that multiple relists, like what is currently happening with these cases, I believe the Duncan case maybe has 5, and the Viramontes case now has 4 relists. The more that happens, potentially the worse that could be for these cases, and it could be a bad sign. Similar to what we saw happen with the Snow rifle ban case. That one was relisted, I believe, like 10, 11, 12 times, and then eventually was denied by the Supreme Court. And then you just simply had a dissent from Justice Thomas, and then you had a statement from Kavanaugh. What that means is that all the data shows that a case becomes less likely to be granted review. The more times that it is relisted, the chances kind of drop more and more as it's relisted more. Now, that's not to say that there are no cases out there where there have been, 10, 11, 12, even 14 relists, and the Supreme Court still granted review to those cases. In fact, Bruin had, a high number of relists. The Cargill bump stock case had a high, amount of relists, and it was still granted review by the Supreme Court. So the chances are not zero, but it is something concerning that we need to keep our eye on, because as they continue to get relisted more and more, it could be an indication that the Supreme Court is simply going to deny these cases, punt them once again, and maybe you would simply just have a dissent in these cases. To this point, the Supreme Court has avoided the whole rifle and magazine ban issue kind of like the plague. However, we will know very soon whether Kavanaugh's promise that they will take up this rifle ban issue in a term or two was actually a very true statement, or just another empty promise made by the Supreme Court to try to keep everybody happy. And we'll find out once again after this conference this Friday on January 16th, when the rifle ban and magazine ban case go to conference once again. We're going to keep our eyes on the order list, the following week, to see ultimately what the Supreme Court decides to do. So that is what's currently happening in these critical rifle and magazine ban challenges, which are once again being pushed out to another conference. As we get more information, as it develops more, I will let you guys know. If you guys like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm, or Al Gore's rhythm. It adds fuel to his jet and just tells the YouTube algorithm that you appreciate this type of two-way content, and it should share it to more people. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.